No. Sorry. I'm trying to make some.
Yeah, I'm early.
Yeah.
I was in your position.
Did you do it?
Yeah, I did.
Nice.
I stayed, that's because yesterday was the years of the final, the fires for the World Cup, and I had to watch it, so I watched it after class.
You're doing it as you're doing it?
Yeah.
That makes sense. Probably do it as you're going to. Okay.
Yeah. I did both.
Oh, the Olympics are on.
Yeah.
Can't wait for the next ones. Should be awesome.
That's what I was saying. But it's gonna be a lot more. Well, I took this out of the game.
Yeah.
Because I'll get distracted. And then since game, 5-year-old heart.
Really? Why? Clovers?
Because it was a Canada US game and then there was like soccer. It's like always like a rivalry. Yeah.
Gotcha.
Bless you, whoever's coughing.
Sorry.
Okay. So everybody read Erie, the chapter on Erie? And you all understand it, right?
Yes.
Kind of.
I only heard one person.
Kind of.
Kind of. Yeah.
Kind of.
I'm on board with the tradition.
Keeps getting mentioned.
Say what?
Keeps getting mentioned for sure. Like all the cases.
Yeah, it was all on the ears.
Well, this is good because we got 5 cases. So each one of you is going to get one.
Okay.
So let's get started. We start with the Rules of Decision Act, which is now 28 USC 1652. But originally it was a provision in the first Judiciary Act. And it said, in pertinent part, the laws of the several states shall be regarded as rules of decision in the civil actions in the federal courts. What does that mean?
Can you repeat it?
What?
I said, can you repeat it?
Say that again.
Can you repeat it?
Yeah, the Rules of Decision Act. It said, in pertinent part, the laws of the several states shall be regarded as rules of decision in the civil actions in the federal courts.
So state law.
This is getting worse by the minute. You guys get any
Telemarketing
Yeah.
calls, yeah.
crappy calls? I mean, it's like getting, see, I'm gonna give them a message.
I got a voice message today on my personal phone in Mandarin.
What?
From a cousin Mandarin, yeah.
My cousin.
I mean, this,
I work with somebody that.
okay, I turned it off. But today I must have received at least 4 or 5 calls from quote unquote unknown callers. All from LA. This one was an 800, so. Well, that's even worse. What happened?
You press the button on the marker.
No, I got this thing. What button?
The exit.
Oh, well, we'll get back. So, read it one more time. The laws of the several states shall be regarded as rules of decision in the civil actions in the federal courts.
State law trumps federal law.
Well, there is no federal law. So, civil procedure, if you got a case, if you file a case in Ohio, federal court, then Ohio state civil procedure is the law. Okay, that's pretty easy, right? So whatever state you file it in, that's what civil procedure rules you get. Okay? This was before the rules of civil procedure. All right. So all you had to do was look to the state law. But that was before Swift versus Tyson in 1841. And it's Swift versus Tyson, that's on page 256. That was a diversity case filed in federal court, New York. It was a suit on a promissory note. New York had substantive common law, and a number of defenses could be asserted under New York common law. Under federal common law, there were no defenses. That's why they filed it in New York. The issue was how many defenses could be asserted. And the rule by Justice Story, who's a famous old 19th century justice, was that state common law precedents are not law. Only state statutes are law. Okay? Going on to apply that rule, which was a new rule, the court said that federal courts are free to decide their own common law. In this case, the district court in New York is free to decide how many defenses could be asserted based on federal common law. What was a federal common law? No defenses. So the plaintiff was SOL. Does anybody know what that means?
Shit out of luck.
SOL. That's a legal term. Okay? So a plaintiff's SOL, since there's no defenses in federal common law, it was suit for a suit on promissory note. There was no defense. Then we get to 1938. So we went for almost 100 years with the federal courts being free to assert common law unless it was a state statute or statutory law. The federal courts applied their own common law. And then we get to poor Mr. Erie. I mean, Mr. Tompkins. Who would like to talk about Erie versus Tompkins? Shall I assign it?
I could do it if you want. If you want to decide, that's okay. I'll volunteer, but if you want
to take a shot.
Okay. So the case involves Mr. Tompkins. He's the defendant, and the Erie Railroad is the plaintiff. It takes place at the U.S. Supreme Court in 1938. And the facts are that the plaintiff was walking along the railroad tracks in Pennsylvania at a safe distance, and he was hit by the train car, the open door of the train. This knocked him onto the track, and the train severed his right arm. So under Pennsylvania law, he was trespassing, and he had to prove wanton negligence. But under New York law, only regular negligence. So he was better off suing in New York to prove negligence. Plaintiff sued in the federal district court. The district court instructed the jury to find the defendant liable if guilty of ordinary negligence, and the jury returned a verdict of $30,000 for the plaintiff.
Wait, let's go back. What was the Pennsylvania law?
Pennsylvania law was that you had to prove wanton negligence, which is harder to prove. It's better for the defendant.
It's harder to prove. It's harder to prove.
Right.
And it's better for the defendant.
Right.
Okay.
That's how
do we know what the New York law was?
The New York law was you just had to prove negligence.
Actually, the court doesn't really say, but you can infer that it was probably just straight negligence. Otherwise, why would they file it in New York?
Right.
Okay. But the decision doesn't actually say, by the way, New York law is just ordinary negligence. You just infer it. Okay. So what happened?
So what happens to district court? He won in district court, and they gave him $30,000. The issue is what state law applies.
$30,000 for an arm?
Yeah, that's not much, but it's 1938.
Yeah, that's true. It was the Depression.
Yeah, it's true. That was a lot of money there.
Yeah.
But
All right.
I have that the issue is
Well,
whether
what law did the federal court apply?
they applied, I thought, state law of New York.
No.
Oh,
Federal common law.
federal common law. Okay, sorry.
In other words, they were following Swift versus Tyson. And the federal common law was ordinary negligence.
Okay.
Okay?
And I know that they overturned Swift versus Tyson. I mean, they overruled it. They overturned it. So the reasoning behind it was that the Swift versus Tyson standard was incorrectly assuming power not given, not abiding by the state case law and giving judges discretion as to what law applies prevents the courts from being uniform.
Okay, so there's by the way, the justice who wrote this opinion is Brandeis. He was a really big giant. You'll see when you in common law, Brandeis is all over the place. Okay? He and Oliver Wendell Holmes. So go ahead. Is there a rule that we can derive from this? What's that?
That all of the state's law apply, including case law.
Do you have a rule for this case?
Well, I have one. It says this court is now of the view that the laws include decisions, and it's unnecessary to go further and declare that the course pursued was unconstitutional. I don't know if that's a rule.
Okay, do you have anything else? Or is that it?
That's it.
Okay. So this is Erie. the whole chapter is about the Erie Doctrine, so Erie is a big deal, okay? For some reason, the last line doesn't come up, but rule of Erie versus Tompkins is federal courts sitting in diversity. Notice, sitting in diversity. What does that mean?
When you're in federal court under complete diversity and amount of controversy.
Well, let's say, put it another way. It means that if it's not in diversity, then Erie versus Tompkins doesn't apply to federal questions.
Right.
If the jurisdiction is federal questions, we're not talking about Erie. Okay? Get it?
Yep.
Federal court sitting in diversity must treat state court decisions as a source of law when determining which legal principle to apply to a case. The basic rule is, in diversity cases, state substantive law applies to the substantive legal issues, and federal rules apply to, you don't see it down there, but it's procedural issues, okay? In other words, in diversity cases, state substantive law is the substantive law, okay? And federal rules of civil procedure apply to all procedural issues, okay? Got it? Okay.
Got it. Thank you. Thank you.
There were two bases for this decision. The first was they reinterpreted, quote unquote, the term laws or rules of decision of the Rules of Decision Act. And the second was the Constitution. The court found that federal courts are not empowered, as you said, to create substantive common law applicable to a state. The court went on to write, that there is no federal common law. So now it's taken Swift completely over, okay? There's no federal common law. The federal courts cannot make determinations on the basis of federal common law. The most important part of Erie is what is called the twin aims of Erie. What? You got to remember this. The first aim of Erie is avoidance of foreign shopping. Do you know what that means?
Yes.
What?
The courts want to avoid people who just choose a court based on what they're gonna, what's their best deal gonna be? What are they gonna get? How much better of a decision?
They want to avoid plaintiffs shopping for courts, meaning are we going to decide, are we going to file this in state court or federal court based upon whose law is more favorable? Okay? So that's the first aim, and the second aim is uniformity. Okay. Wanted to avoid inequitable we'll just call it results, but it's the inequitable administration of justice, okay? So they want, what that means, uniformity, is they want the results in federal court to be pretty much the same as they would be if it was filed in state court. So if you have results in federal court being essentially the same as in state court, you're also avoiding forum shopping, right? It's twofold. But when you're answering questions like an essay and there's an Erie issue, first you state the rule, okay? In federal court, sitting in diversity, the federal court must treat state court decisions as a source of law when determining which legal principles to apply. Okay, or in diversity cases, state substantive law applies to substantive legal issues and federal rules apply to procedural issues. But then you have to go on when you do your analysis and you have to say the test is the two twinings of Erie, okay? And then if you're analyzing the facts, you'll analyze it on the basis of those two aims. First, is this, if the court applies federal law, will that promote forum shopping? And if it applies federal law, will the result be the same as it would be in state court? But you got to say uniformity first, okay? So in this case, the court said, when applying Erie, whether alone, which would be pure Erie, or in combination with other approaches, courts most often discuss it in terms of those two aims. And according to the court, Swift versus Tyson resulted in grave discrimination by non-citizens against foreign state citizens, and that was one of the main concerns of the court in overruling Swift, and that's the uniformity part. It went on to say that in applying the new rule, the circuit court should have applied Pennsylvania law for duty of care, not federal common law. And it said there is no federal common law. It was reversed and remanded for further proceedings. The railroad won. Just as a matter of how you look at these cases, is this is a preview to con law, okay? You guys have just finished part 1 of con law, okay? There's been almost all Supreme Court decisions, right? What was going on in 1938? What was the main source of transportation in 1938? Railroads. Who do you think were the big dogs? Railroads. Okay. And this court in 1938 was a conservative court. Most of the justices have been appointed by Republican presidents in the 20s. Harding, I don't know if Harding got any or not, he died real quick. But he had Harding, Hoover, and Coolidge. Okay? And so these were really conservative justices, so much so they were overturning New Deal cases. Okay? That Roosevelt was talking about packing the Supreme Court. You know what that means? back in the Supreme Court, what do you think? Putting more justices on the Supreme Court, just like Democrats today are talking about packing the Supreme Court. Okay? It never happened. So that's what's part of what's behind this, is that they didn't want to impose rules that would impede upon the railroads. All right. Yep. A number of cases that have interpreted Erie since 1938, and it comes in three phases. The first phase was 1945 to 1965. That's 20 years. And they call this the constitutionalization or constitutionalizing of Erie, where they redefine Erie. The second phase is from 1965 to 1996. That's called the statutory retreat, where the federal rules of civil procedure and other statutes become preeminent. And then 1996 to today. We'll talk about that in a minute. Okay? So the first phase, 1945 to 1965, the constitutionalizing of Erie, is represented by Guarantee Trust versus York on page 268. Anybody in love with Guarantee Trust?
I'll try it.
Okay.
Okay, so in Guarantee Trust v. York, York was the initial plaintiff and Guarantee Trust was the defendant, a bond trustee and he sued him for misrepresentation and breach of trust and federal diversity. And it was governed by New York substantive law. Defendant claimed that the suit.
Who was he? Who was the plaintiff?
York.
Yeah, but what was he?
I'm not sure it said.
He was a bondholder.
Oh, bond trustee.
You know what a bondholder is? You know what stocks are?
Yes.
You know what bonds are?
Yes.
You know what a stockholder is, right?
Yes.
A bondholder is someone who owns bonds.
Okay.
And who's Guarantee Trust? Trustee.
Yeah, I thought he was the trustee, right?
Guarantee Trustee
Is
is
the trust.
it's a trustee. Guarantee is a Guaranteed Trust is a trustee.
Trustee. Okay.
Okay.
So the defendant claimed the suit was barred by the statute of limitation which had run. And York argued that it was not barred because it was on the equity side of federal court. There was a tradition within the courts of equity that they were not strictly bound by the statute of limitations, and therefore the Second Circuit ruled that.
Whoa, let's go back. Whose law was the statute of limitations?
That was New York. That was state law.
Okay, New York state law. So they were applying New York statute of limitations,
Yes.
right? And what did the second district?
Well, they said that they followed tradition more than the state law, and they said that they were not barred by not bound by the statute of limitations, and therefore that plaintiff was not barred.
Because it was inequity.
Yes, because it was an equity.
Okay, so what's the issue?
Does a federal diversity case have to abide by state rule if the outcome will be barred, or can the court of equity take cognizance of the suit? What I have as.
What do you have as the rule?
Where a federal court is exercising jurisdiction solely because of the diversity of citizenship of the parties, the outcome of the litigation in the federal court should be substantially the same so far as legal rules determine the outcome of a litigation as it would be if it tried in a state court.
That's good.
And so applying that rule, What the court said here is that, in order to maintain, I guess, uniformity, they had to follow the state rules, because if they were to follow the federal rules, it would be a completely different outcome. He would be barred. I mean, he wouldn't be barred, and if they followed state law, then they would be barred. So, trying to maintain uniformity, they had to follow state.
Okay. So they reversed the second district, right?
Yes.
All right. I've got, if, in this case, because there was a statute of limitations, and you're gonna see, you know, especially in multiple choice questions, a lot of statute of limitations questions, okay? So I framed the rule here as one of, first of all, applying to statutes of limitation. If a state law claim is barred by the statute of limitations in the state court, it is barred in a federal court. And the court said, quote, as you said, we want the results to be the same. That's the uniformity thing. The accident of a suit by a non-resident litigant in a federal court instead of in a state court a block away should not lead to a substantially different result. So this is referred to, guaranteed trust is referred to as the outcome determinative test. Okay? There are a number of cases. You can sit. Okay, thank you. Really good. Cases following guaranteed trust are on a chart on pages 270 and 271. You guys see that chart? So there's 4 cases. What was the result in those 4 cases?
State law.
Yep. So from a test-taking point of view, if you use the outcome determinative test, what's the result going to be? State law. Okay. Looking at this every time, right? Okay, we got the next set, the next phase, 1965 to 1996. This is where the federal rules and the statutes are preeminent, and that's Byrd versus Blue Ridge, a 1958 case. This looks like a Clara case.
This is a workers' comp case.
So tell us, first of all, tell us about workers' compensation immunity. What does that mean?
So if you file workers' comp, a personal, like an injury under workers' comp, like just like this one, you cannot file it in the civil court. So
No, that's not true.
not the same case. You can't.
No, workers' comp immunity is immunity on the part of the employer if they carry workers' compensation insurance, okay? You can't, if they carry workers' comp insurance, then the sole remedy for the plaintiff or the injured employee against the employer is workers' compensation. They can't sue their employers. That's workers' comp immunity, okay?
Yeah, that's true.
But they can sue any other corporation or entity that may be involved in the incident that caused the injury other than the employer. for example, in a products liability case, and there are a number, and somebody's working, let's say on, what do you call it? One of those cranes, right?
Forklift.
Yeah, forklift. Right. And they work for, the guy is working on a movie set. And he's on the forklift, and in the process of whoever's operating the forklift, moving it around, it hits some telephone wires and the guy's electrocuted. Okay, and the guy works for the motion picture company, one of the 20th Century Fox, one of the studios. He can't sue 20th Century Fox if there's any negligence on the part of 20th Century Fox. But you can sue the manufacturer of the forklift. You can sue the electric company. They get sued all the time, by the way. Oh, yeah. So that's an example of, okay, you can sue another entity, you just can't sue the employee. So let's get back to Clara.
Okay. Okay, so plaintiff, which is Bird, he was injured. He was connecting power lines, and he was an employee of a subcontractor of Blue Ridge Electronic Corporation.
Which is the electric.
Right, which is the defendant. So he sued them in federal court under a negligence theory. And
What state was it, by the way?
he was a citizen of North Carolina, and Blue Ridge was a South Carolina corporation.
Yeah, but where did he sue?
In let me see here. Well, he sued the Supreme Court of South Carolina. Oh, wait a minute.
Yeah,
Is that
South
this? It's
Carolina.
South Carolina. Okay. So the defendant was alleged that he should have sued under the Workers' Comp. It should have been under the Workers' Comp Act of South Carolina. And let's see here. So there was an issue between, the trial judge jumped in and it said that the interpretations that the...
Okay, wait a second, let's step back. And in South Carolina, and this isn't that unusual, this is pretty standard stuff. South Carolina, if the employee is determined to be a special employee of the defendant, then the defendant gets workers' comp immunity just as though they were the employer.
Right.
So there was an issue of whether or not Bird was a special employee of the electric company. Okay, Bird worked for a subcontractor hired by the electric company. Okay, so the question was Bird acting
As an employee for Blue Ridge?
employee of Blue Ridge, the electric company? Okay, you said now the judge stepped in. How come the judge stepped in?
Well, because they wanted the judge to make the decision and not have the jury.
Who's they?
They meaning the defendant, Blue Ridge.
Well,
They were pushing, the defendant did not want this case going to federal court. They kept insisting that this was a workers' comp case and they wanted it dismissed.
no. Under South Carolina law, there was no right to a jury trial on the special employment issue. Okay?
Okay.
So the judge decided special employment because state law required him to decide special employment. All right?
Uh-huh.
And what did the judge find? Wait a minute, let me go back. Yeah, there was no right to a jury trial. What was federal practice? You know, could you figure that one out? Jury trial.
Okay, the jury trial, because they reversed it and said that there should have been a jury trial.
Well, but that's, no. You're taking the cart before the horse.
Oh, okay. I'm jumping all the way to the end.
What's the federal practice? The federal practice was you had a right to a jury trial.
Uh-huh.
So the question is, which law should govern? Should it be South Carolina law that says it's a court issue, or federal law which says you get a jury trial? How did the South Carolina court rule?
It said that South Carolina law cannot be allowed to preclude a right to a jury.
Right? And what did the court find with respect to special employment, or did it?
I think it did say that there was special employment on him.
Well, the Blue Ridge was contending that the state practice infringed on the Seventh Amendment. It's a Seventh Amendment U.S. Constitution right to a jury trial, and federal law should apply. So you think Blue Ridge liked what the court did?
No.
So they found that he wasn't a special employee. The judge found he wasn't a special employee. Blue Ridge has taken it up.
Uh-huh.
Okay? So I got trial judge applied state law and determined Bird was not a special employee. There was no immunity, and Blue Ridge appeals. So what do you have as the issue?
I asked if I put down, because they did talk about the Erie Doctrine, if it required that the state determinations of rights were upheld with federal determinations.
What's the rule or the test here? What is it?
So the test was, I have the Erie Doctrine required that federal courts in diversity cases must respect the rights of the state courts.
That's what you got.
That's what I got.
Well, what was the result here? Then that would mean that they should get, that it's okay to have a court trial and not a jury trial. Is that right? What
I
was
think,
the
okay. They did reverse it. They said that let's see, the likelihood of a different result, okay. To require the federal practice of jury determination of disputed factual issues to yield to the state rule in the interest of uniformity of outcome. So no, they did want the jury trial. So they did rule towards the jury trial.
Okay. So then they reversed it.
They reversed it.
Okay. So the issue is, thank you. The issue is whether the federal policy favoring jury decisions of disputed issues of fact outweighs the state rule in the interest of furthering the objectives of Erie, that the litigation should not come out one way in federal court and another in state. And Brennan formulated yet another test. This one's called a balancing test. He writes that outcome determinative analysis was never intended to serve as a talisman. What is a talisman? Huh? Yeah. Huh? It's like a religious artifact, right? Yeah. Or the Ten Commandments. Okay. This would be a talisman.
Yeah.
See? That's got the Ten Commandments in it. Okay? It wasn't intended to be a talisman. It says balancing the interests of federal court in the integrity of the federal system versus state interest in its system is the test that it's going to use, or it used in that case. It says federal courts may reject a state rule if, one, there is a strong federal policy against allowing the state rule to disrupt the federal courts. That would be the interest of federal courts and the integrity of the federal system. And the federal rule is not outcome determinative. That would be, that would promote the state interest in its system. Okay, so that's, now we've got a balancing test. So the rule is federal courts may reject a state rule if there is a strong federal policy against allowing the state rule to disrupt the federal courts. And two, note, and. That means you got to have both of them. The federal rule is not outcome determinative. Okay? So in this case, the court ruled that the federal practice of jury determination of disputed factual issues should not yield to the state rule in the interest of uniformity of outcome. And it's really, this was really important because you're talking about the right to a jury trial. Okay? And the Supreme Court wants to promote the right to a jury trial. Okay? So it was reversed and remanded. And it says a jury should decide special employment. So what's your takeaway for tests? The court's retreating from guaranteed trusts outcome determinative tests when there's an essential federal right, like the right to a jury trial. Okay? If there's not an essential federal right involved, probably not a balancing test. We've also got a case called Hannah versus Plumer. You want to do that? Okay.
So very little facts in this case, but this is what I got. It says the case arose out of a diversity suit for personal injuries and defendant with the state of one of the drivers involved. And so the issue arose because the Massachusetts law provided that suits.
What was the lawsuit?
Personal injury, I guess, for negligence.
Wrongful death.
Oh, I don't know, I didn't get that.
Yeah, it's a wrongful death out of an auto accident. So somebody died as a result of an auto accident.
Oh, yeah.
And what state was it filed in?
It was filed in Massachusetts.
Okay.
So, so next thing I only got from here was the issue arose because Massachusetts law provided that suits against an estate required personal service process on the state's executor. I take it wasn't personally served. Is what happened.
What did Massachusetts law require?
There must be personal service on the state's executor.
Yeah.
And
Now,
so
what was the federal rule? What was Rule 4?
Rule 4.2 something says it allows for the summons and complaint to be left with a competent adult at the residence of any defendants, and which
That's substituted service.
yes, substitute service.
Yeah, so substituted service is okay under the federal rule. Okay,
Okay, so
what did the plaintiff do in this case?
they serve the what was it?
They served the defendant. It doesn't matter.
The wife of the
Yeah.
resident.
Yes, that's substituted service.
Right.
So whose law did they follow?
Oh, in the trial court.
No.
Oh,
Whose law did the plaintiff follow
Oh, they followed
in serving the wife?
the federal.
Right, and they are suing in federal court. So they followed federal practice, not state practice. Okay? And what did the court do?
The district court first rule said that they cited Reagan, saying that the rule that the claim should be dismissed because plaintiff failed to comply with the state method of serving process
Okay,
with this statute.
right.
Okay. Okay.
So what's the
The
issue?
issue then is whether in civil action where the jurisdiction of the U.S. District Court is based upon diversity of citizenship between the parties, service and process shall be made in a manner prescribed by state law or set forth in Rule 4, the federal rules of civil procedure. So the rule here, the court decided to go with Rule 4, saying that
What test did they use?
They said allowing for the summons and complaint to be left with a competent adult at the residence of any defendant as right under Rule 4 that is the standard for which the federal court should measure the adequacy of the service.
Well, did they use outcome determinative or did they use the balancing test?
They use the balancing test.
Okay, so how did they apply the balancing test?
Okay, well, they went into discussing about the rule on the Enabling Act. So 275, you want me to read that?
Yeah.
Okay, so The Supreme Court shall have the power to prescribe by general rules the forms of process, writs, pleadings, and motions, and the practice and procedure of the district courts of the United States in civil actions. Such rules shall not abridge, enlarge, or modify any substantive right, and shall preserve the right of trial by jury. So they said, right off the bat, that Rule 4 complies with the rule. And the United Kingdom.
Rule 4 complied with the rule enabling. Okay.
So then they get into the role. The defendant argues that Erie demands application of Massachusetts rule, and once again, we describe that Erie can only be read as a discouragement of forum shopping and avoidance of inequitable administration of the laws.
Yeah.
So,
Formative.
and so
What did they find?
the court says it's hard to believe that enabling course of service of defense state would raise outcome determined question in Erie. So they said it's a brilliant issue under Erie.
So whose law applies?
Whose law, it will be the
Rule 4. Right? Which is
appropriate.
right. So it shouldn't have been dismissed. So they reversed. Right?
Yes.
Okay.
Yeah.
Well, let's talk about Hannah a little more detail. It was decided by a guy called Warren. You ever heard of Chief Justice Warren? Like the Warren Court? Okay, so this is like a big deal case. The Supreme, Earl Warren wrote this opinion. And he says, if a federal rule is involved, we get another one. This is slightly different. If a federal rule is involved, the questions are, first, does it violate the Rules Enabling Act? If no, that means if it doesn't violate the Rules Enabling Act, is it constitutional? If the answer is yes, is it constitutional, the rule prevails. You follow the federal rule. If no, the rule does not prevail. So, first of all, how often do you think the Supreme Court has found that a federal rule has violated the Rules Enabling Act? What do you think? What? Why? You're shaking your head. Never. Never. How often do you think? Who writes the rules? Who proposes the rules to Congress? The Supreme Court. Okay. So how often do you think the Supreme Court has ruled that one of the rules that it proposes to this Congress is unconstitutional? Never. Okay. So this is an interesting proposition. If a federal rule is involved, the questions are, does it violate the Rules Enabling Act? You're going to say they've never ruled that a rule violates the Rules Enabling Act. And if it doesn't violate the Rules Enabling Act, is it constitutional? Well, it never ruled that one of them is unconstitutional. So the chances are slim and none that it's going to rule that this federal rule, okay, is unconstitutional. Therefore, the rule applies. Okay? You're pretty safe in saying there's a federal rule involved. the federal rules going to apply citing hence. Okay? Second, if there's no federal rule involved, that is federal practice versus state rule or practice, the analysis is pure, quote unquote, pure theory. Okay? That means if the federal procedure violates either the twin aims of Erie, state procedure prevails. If not, then the federal procedure prevails. Okay, so that pure Erie means the twin aims of Erie. Okay? In this case, the court, Warren wrote, the Erie rule has never been invoked to void a federal rule. A federal rule has never been found to violate the rules enabling it or the Constitution. And the rationale is to hold that a federal rule of civil procedure must cease to function whenever it alters the mode of enforcing state-created rights would be to disembowel either the Constitution's grant of power over federal procedure or Congress's attempt to exercise that power in the Enabling Act. In other words, we're going to give great preference to the rules of civil procedure because they were enacted by Congress after we told them to. They don't say that, but okay. So if no federal rule is involved, federal practice versus state rule of practice, pure Erie. In this case, the question is, would federal practice jury trial, I'm sorry, process, service of process. The question is, would federal practice, and their practice was substituted service, okay? Would that practice encourage forum shopping or result in an inequitable administration of justice? Here it says that it wouldn't encourage forum shopping, and the result would not be an equitable administration of justice. Okay? So state practice doesn't prevail. Federal practice prevails, and it was reversed. The takeaway from this case is federal law prevails in most cases. Okay? We've got a number of cases. There's Burlington North Railroad versus Woods, 480 USC 1, that's 1987. The Rule 38 penalty of costs for frivolous appeals prevailed over Alabama's 10% penalty. Stewart Organization versus Ryko, 487 US 22, 1988. The 28 USC section 1404, giving federal court discretion to transfer to another district, displaced Alabama's statute making forum shopping selection clauses unenforceable. And Shady Grove versus Allstate, 559 US 393, that's 2010 case, written by Scalia. He held that Federal Rule 23, defining class actions, displaced the state definition for class action. Okay, these are all examples of federal law prevailing over state. Okay? Then we get to the 1996 case of Zemtech International versus Lockheed on page 283, 2001. Daniel, you want to do this one?
Yep. So Semtech International is the plaintiff, and they sue Lockheed Martin Corp. In California State Court for breach of contract and business tort claims. I don't think it's specified which, I think it just says various. So the case was removed on the basis of diversity citizenship to federal court
Where was this filed?
in Baltimore.
Lockheed, you know where Lockheed is usually, at least at that time, or, yeah, it's still there.
Oh, so is it in California?
Yeah. Probably filed in LA. Where's Lockheed? Torrance. You didn't know, huh?
Yeah,
That's right, you're from Massachusetts.
yeah, I
Okay.
have no idea.
Yeah, no, Lockheed's like a big employer out here. Okay. And when the aerospace industry was really big, there was a lot more employment in the LA area. At any rate, Lockheed's still there. So they sued in California State Court, and then they removed it to California Federal Court on diversity.
Yeah, and then Lockheed moved for dismissal, saying that Semtech's claims were barred by the 2-year statute of limitations in California.
Right.
The court dismissed the claim, and then Semtech refiled the suit in Baltimore.
Did they dismiss with prejudice or without prejudice?
Without
No.
a 50-50 shot.
With.
Okay.
You know, so with prejudice means they should, the plaintiff shouldn't have been able to refile again, right? That's what with prejudice means. It's dismissed with prejudice, that means you're SOL.
I always get those two mixed up because in my head that doesn't make much sense to me.
What? With prejudice, you know, what does prejudice mean?
I get what you're saying.
If you send a CIA operative to terminate someone with prejudice, what does that mean?
That there's a reasoning behind you terminating.
You're gonna kill somebody. If a spy is sent to eliminate someone with prejudice, that means
There's a prejudice against them.
they're dead. That's what it means, okay? If you eliminate somebody with prejudice, that means that they can't come back, okay? If you dismiss a case with prejudice, it means for all practical purposes, the case is dead. You can appeal it, okay? But unless you get a reversal from the higher court in the forum that dismissed it, it's gone, okay? That's what with prejudice means.
I think I'm just thinking of our evidence class and undue prejudice and how it's unfair, so you would think they'd be able to refile. That's just stuck in my head, I guess.
Yeah,
So
okay.
I'm trying to get it
I'm
out.
just saying, when you hear
It means
something's
dead in the water.
dismissed with prejudice, that means you can't bring it again.
Okay, then how did he bring it
And
in?
without prejudice means you can bring it again.
In the same court you're talking about? Because clearly he was able to bring it again because he filed it in Baltimore.
Well, isn't that what this whole case is about?
Yeah. So you're saying
The
that,
fact that he did it doesn't, yes, he can bring it in another court, but is he allowed to bring it in another court?
well, that's what the issue is.
That's what the issue is, yeah. Okay, so he refiled it in Maryland State Court, right?
Where there was a 3-year statute of limitations.
Right.
The court dismissed the claim on the ground that the dismissal of the case on its merits in federal court precluded the claim, which is called res judicata, from being raised in state court. So the Maryland Court of Special Appeals affirmed that decision. So the issue is whether claim preclusion of a federal judgment dismissing a diversity action on statute of limitations is determined by law of the state in which the federal court is sitting.
Say that again. What's the issue?
Whether claim preclusion or the claim preclusive effect of a federal judgment dismissing a diversity action on statute of limitations is determined by the law of the state in which the federal court sits.
Right. And this is a Scalia decision.
Yeah.
How did you find Justice Scalia to be easy to read?
Not particularly difficult.
Okay. Okay, so what's Scalia rule? Or-
So there's no need for a uniform federal rule because existing federal law doesn't resolve the state law issue.
Okay. What's the result?
That the Maryland Court of Appeals erred in holding that the dismissal necessarily precluded the bringing of the action in Maryland courts. So he says, existing federal law doesn't resolve an issue since it's a state law issue. He says to hold otherwise would encourage forum shopping and inequitable administration of laws since parties would seek to remove federal court cases under diversity jurisdiction for their claim preclusive effect on cases brought in state court. So then he says here,
What was the result?
reverse. But he says the case was dismissed in federal court only because the statute of limitations barred claims older than 2 years, but there's no federal interest in giving that limitation more effect than it had.
Okay. This is an unfair burden on you
Why?
because this is about claim preclusion and we haven't done claim preclusion yet.
I've been exposed, I know what claim preclusion is. It's essentially, you can't relitigate another claim that's already been litigated on.
Yeah, right.
Yeah.
So they found that the Maryland court found claim preclusion. And that's why they reversed. Okay? And Scalia says, no, they shouldn't have found claim preclusion. Okay? But that's not what this case stands for in terms of Erie. That's what I'm saying. It's an undue burden on any student who hasn't taken conflicts of law and claim preclusion. That's all I'm saying. Okay? So let me kind of run this by you, okay?
Okay.
But that was a good effort. What Scalia ruled in this case is that federal common law governs choice of law. Okay? For claim preclusive effect of a dismissal by either a state or a federal court. Okay, so when you're determining which law applies to claim preclusion, whether it's state or federal, you use federal common law to decide which law applies. Okay? So in this case, what that meant was that they used federal common law to determine whether or not California's law regarding the statute of limitations or federal law regarding the statute of limitations applies. I'm sorry, where Maryland's statute of limitation applies. Okay? Got it? Then the court goes on to say, using the Erie approach, the preclusive scope of a federal judgment in a diversity action should be the same as the judgment would have been had the case been brought or remained in state court. There was no federal constitution or statutory provision involved. So the next step is he looked at Rule 41, which was dismissals on the merits, because they were arguing that, well, Rule 41, Federal Rule 41 applied. And he said Rule 41 doesn't apply because it applies claim preclusive effect to refiling of claims in the same court, not other courts. Okay, so if it had been refiled in California, they could have used Rule 41, but since it was refiled in Maryland, no. So then they looked to federal common law. And the federal common law was the preclusive effect of a federal judgment in a diversity case is determined by federal common law, and the best principle to follow is to give the judgment the same effect as it would have been given by the state courts of the federal district court. What's that common law?
The federal common law?
Yeah,
Okay,
that's Erie.
I'm confused because when we were doing Erie, you said there was no federal common law. So now
That was another case.
I understand that, but
That was another case.
at an earlier time, but now they're saying there is.
Now you've got Scalia saying there's federal common law. What do you think of that? Doesn't make sense, does it?
Not much, yeah, no, it doesn't.
Okay. Well, but what federal common law is in this situation is Erie. Get it? Erie's common law. A court decision is common law.
Yeah, but wasn't the Erie ruling that you're applying state law, so how would that be federal common law?
The federal common law is, in this case, the twin aims of Erie. Okay,
Okay, I see.
got it?
Yeah, I got it.
All right, so they're saying, in this case, would it promote forum shopping to find that Maryland's law applies? That's forum shopping, isn't it? Right?
Right.
And you want uniformity, you want the same result as though it was filed in California. Okay, so Erie applies. So what I've got here for the takeaway for you on tests, guys. Trish, are you awake? Or did I put you to sleep? Can't hear you, babe. Didn't want us to hear you snoring, huh?
I was taking notes about the uniformity, that they want the same result.
Okay, so takeaway I got here for test approaches. If you get a choice of law issue, that is whose law applies, you're gonna follow federal common law, whatever that may be. In an Erie situation, the federal common law is
State law.
Erie. What? No, do the twin aims of Erie, okay? And with respect to the preclusive effect of a statute of limitations, you're gonna, on statute of limitations, you're gonna follow state law. Okay? So Erie gets you to determine whether or not federal or state statutes of limitations apply. So you're gonna say federal common law, Erie applies to determine whose law applies. But Erie was determined in Lockheed versus Semtech to be on a statute of limitations case that state law is going to apply. So federal law gives you state law.
Yes.
Yeah, so here's Semtech versus Lockheed. Federal common law governs choice of law, except where state law is incompatible with federal interest. So now we've got basically 3 different tests that the court uses from all these cases that we've just looked at. Which one do you think the court uses? For Erie. We just went through 3. We got the outcome determinative test, right? That was the first one. Then we got the balancing test. And now we've got Scalia's. Even though we previously said that federal common law doesn't apply because there is no federal common law applies when determining choice of law. Okay? So we can use federal common law again. the three you think they use? If you were gonna answer a question on that. Going once, going twice?
I think number 3. Score number 3.
Scalia?
The federal common law, yeah.
Yeah, okay. Anybody else? How about outcome determinative? You like outcome determinative? Balancing?
Balancing,
No, they use all three.
Oh,
So if you're writing an Erie answer, you're gonna say there are 3 different tests, right? Outcome determinative, balancing, and the Lockheed case, or Semtech, whichever one you want to call it, or the whole name. Okay, where the court may apply federal common law, and the court doesn't have, at this point, any particular, hasn't indicated that any one of them is preferred. So you have to go through all 3. Under outcome determinative, the answer would be. Under the balancing test, the answer would be. Under Lockheed, whatever, if it's a conflict of interest issue, you're gonna say, well, under Lockheed, it's gonna basically be pure Erie, because we're applying federal common law, which is Erie, and then you go back to Erie. All right? Mind you, Scalia is the guy who says, we don't make law, we don't legislate, right? We only find what the founders intended. But after all of this stuff that we just read, Scalia says, oh, by the way, federal common law, which we previously ruled doesn't exist, okay, suddenly exists, and it's going to apply in this situation. So what's your takeaway from that?
I have to study.
Hmm?
I have to study.
Well, the takeaway is all of this stuff that a lot of the justices talk about, is I'm an originalist, okay, and I don't believe in the court legislating or making stuff up. All sounds really good, but more often than not, the justices are outcome determinative themselves. They get to where they want to go, okay? And if it means making stuff up, don't make it up. That's not going to be on a test. Don't quote me on that. Because
You're being recorded.
yeah, no, I have no problem being recorded on it. I'm saying, don't quote me on it, because if you say Professor Moyer says that they make stuff up, that's not really a good citation, okay? But Justice Black is, and Justice Black said, the Constitution means what 5 justices say it means. Okay? Okay, you guys finished common law 1. Why don't we take a quick break? Jesus. I'm sending you guys something. Okay. I just sent you that. I sent you the,
Thank you.
huh?
Thank you.
Did you get it?
No, not, I mean, I didn't look yet, but I'm saying thank you.
But I also sent you the full jurisdiction Erie approach. So if we take a 15-minute break, then we'll go over that.
Oh, I got it. Thank you.
Oh my goodness.
Wow. Yeah.
This is what you're gonna memorize for in the next week. Okay? So beginning, is the light beginning to go on over your heads a little?
You've read a lot.
Huh?
You need to write a lot.
Well, maybe you do and maybe you don't. Okay? That's all you got. It's 6 pages. And that was an outline form, so. If you were gonna type it out without outline form, it would be less than 6 pages, wouldn't it? Okay? All right, I'm gonna have dinner here. I gotta get ready for a wedding. I'm gonna lose 15 pounds.
When's the wedding?
Huh?
When's the wedding?
3 weeks.
You can do it.
Huh?
You can do it.
I've already lost 4 pounds. Yeah, boy. Dinner. Yummy. Has anybody ever done Jenny Craig before?
What is that?
Have you ever done Jenny Craig?
In fact, no, I've done everything else, but not Jenny Craig.
Food sucks. This food sucks. I can't stand it. They're trying to make it so that you don't want to eat anything.
It's cut us over, but I want it.
Oh, what?
Down, like. No, what?
I thought it was just the Erie outline, but it's like for like.
It's the entire thing,
Yeah.
which is great.
Yeah, it's just great. But when I first saw it, it was just Erie, like.
Yeah, I thought it was just subject and hearing, maybe,
Yeah.
you know, it's just subject matter jurisdiction, but if that's the whole thing, that's actually not that
Yeah,
bad.
I don't know.
No, man, that's what's.
Oh, I know.
Yeah, for sure, dude, I'm not doing it. I don't think he could give us a practice exam on this, and I would know anything.
Like the last night.
Yeah, pretty much all I could write was minimum contacts, minimum contacts.
I know,
minimum
I did that for 3 paragraphs.
This class definitely has the most material I've had in study though.
Yeah.
Very real property and evidence, this class is a lot more stuff.
I don't know, I feel like it's everything.
Well, there's a lot of real property, but not that much. The approaches are easy. Really funny.
Well, hey, you gotta go.
Yeah, okay. Okay.
He might be outside.
Does he smoke?
He has the vapes.
Hmm?
The vapes.
He smokes.
Yeah, he smokes.
Hey, those Fleming's audios, are they they really, make things
to only a little bit, so I can't tell you like if they all do. I listened to, I couldn't even find it, so I don't even know.
You don't know which one?
No, I know it was real popular for sure. What?
Me and Drucker just got locked up.
Okay.
I texted you,
Locked
come let
up.
us in, but as soon as I texted you, Moore came around the corner. Did he come out looking for me?
Yeah,
He talked shit when he said.
yeah, he was like, I'm like, what? Yeah, what I heard it did, but I haven't listened to all of them enough to say it now.
Okay.
Is that Drucker up there?
But I'm gonna listen to all of them.
Okay. So who wants to get out of here fast?
Yay.
Okay, so this is the deal. I'm not gonna go over the whole thing. We'll talk about it some more next week, because I'm gonna give you some tips on how to study for the exam. Okay, so what you're gonna do is, we already talked about this. You got a 3-step test. We know about the long arm statute, right? Do the long arm statute, because you'll get points. Even if you don't see a long arm statute. Okay? You can still do this thing, what is it, you don't have to say, is there a long arm statute? You just go, long arm statute. There's no long arms. What is a long arm statute? Write what a long arm statute is and say, facts here don't seem to indicate a long arm statute, so I'm going to the second step. Okay, if there is a long arm statute, then you talk about the long arm statute stuff. Okay? Second step is the traditional basis of in personam jurisdiction, right? Is there an absolute basis for in-person jurisdiction? That's Penway versus Ness. And you go through this, right? When you're done with that, then you insert, before you go to the third step, your analysis or application, however you want to do it, and go through each one of these things and apply it to the facts. Okay? For example, if there's not a service of process issue, right, then you just indicate, blah, 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 blah. If there is, then go through it. All right? Then you go to the third one. This is the one that's going to be the hardest, is constitutional due process. So you've got to do minimum contacts. Okay? You know that minimum contacts is probably going to be an issue. All right? So don't wait until you get to the entire end of it. First do minimum contacts, and if there are minimum contacts, then you apply the minimum contacts thing to the facts and move on to the next step. And so on, all right? Then when you're done with that, you do fairness. When you're done with that, now you got to talk about subject matter jurisdiction. Okay? Same approach. That's what you're going to need for the essay. And all of the content, which we've studied, what is it, the last 5 weeks? Okay? That's what's going to be in the multiple choice. But it's only going to cover jurisdiction and erie. There's going to be 20 questions, and 5 of them are erie. So figure the rest out. Okay? What I suggest you do when you review everything is really review aggregation. Remember aggregation? Diversity. Okay? Has to exceed $75,000. Remember how you can, the plaintiffs can aggregate in certain instances, and in certain cases, they cannot aggregate. Remember, there was a page in the outline that I gave you and in class, in the textbook, that lists all these different factual circumstances on when you can and cannot aggregate. Reread that and put it into your outlines and memorize it. And maybe you've all got Fleming's, right? So look at Fleming's. He's probably got a thing on aggregation, right? But I'm not gonna spoon feed you every single fact, because you won't remember it if I do that. You got to do that on your own, okay? But I'm telling you, look hard at aggregation, because it's gonna be in the multiple choice questions. I don't remember how many of them there are, but I'm throwing a few aggregation questions at you. And I don't remember whether aggregation's an issue on the essay, and if I did, I wouldn't tell you. In preparing for the midterm and writing the essay, go to that question that we played with a couple of weeks ago, the 2012 State Bar. I think it was July question. And in that one, I just gave you, I think it was just personal jurisdiction. I don't think we even dealt with subject matter jurisdiction. Okay, well, that question also has a subject matter jurisdiction. Okay, there might also be an area, I don't remember. And read the question, then read the model answers that they give you. Don't get intimidated by the answer, because it was probably written by, first in the class at Stanford or something. Okay? But look at the answer and how they write it. And then what I would do if I were you is, after reading that, I'd sit down and I would take the six-page outline and I would do like an open book test and just write it myself on these facts. And that'll help you get into the swing of writing an essay for Civil Pro. Okay? And then I'll give you some more handy hints next week. Okay? But you got a week to do it. Huh? That's pretty good for 6 pages. I mean, the 6 pages is actually 3 chapters. What is it, 250 pages? But that's it. When I took the bar exam, so so you have like 10 classes, right? Each one's about 100 pages in the outline. And so I got it down to 10 pages. And then this friend of mine, about 3 days before the bar exam, calls me up and he says, how are you doing? And I said, I got 10 pages. I don't know what I get the 5 pages. And then when I get the 5 pages, I'm going to get the 1 page. And he said, no. He said, you're going to close all your books and let's go to the beach. He said, you're going to go crazy. But you got 6 pages to play with. Okay? We took 250 pages and we got it down to 6 pages. Okay? We all good?
Yes.
All right. We done.
Thank you for the outline.
Okay, notice it's copyrighted.
And President